appealing the matter of FCC Buckinghamshire Ltd and Buckinghamshire Council.
Ms Parkin.
May it please you, my lords, I appear together with Mr Kayum and Mr Kazmi for the appellant slash respondent slash defendant in this matter, and my learned friend Mr Mort, King's Counsel, together with Mr Macmillan and Mr Coulson, appear for the respondent slash appellant slash claimant in this matter.
Which leads on to a question I was going to ask. Obviously, you have got two appeals.
Yes,
have you agreed between yourselves how to handle the timetable?
My lord, what we've agreed is that we're going to split the time 50-50. Obviously, I'm standing up and I'm going to go first. I'm intending to deal with both appeals together because, as your lordships will have appreciated, both appeals concern intimately the definition and how it's to be construed of the term third-party income in the use of the PA. I'm aiming to finish probably around somewhere between 3 and 3:30 this afternoon. And then Mr Mort will start, and then I will use the balance of my time to respond tomorrow.
And just to be clear, in a very strict sense, one might think that each of you would have a right to reply to the other's submissions.
Absolutely, my lord. Yes.
So is it envisaged that Mr Mort will have covered all the ground in his submission, so he doesn't need to reply on his appeal?
Perhaps I might. The answer is I'm not quite sure. I think.
Well, we did discuss this, and we pointed out that if necessary, we would like a brief reply. So, if necessary, we will have 4 submissions, but we don't want to burden the court with unnecessary.
So, with a bit of luck, you'll have wrapped it all up in your submissions. But if it came to it, you might want a short reply on matters related specifically to your appeal.
Exactly so.
Yep.
I'm obliged, my lord. As your lordships know, these are 2 appeals from paragraph 1.1 of the order of His Honour Judge Davies, sitting as a judge in the TCC in Manchester District Registry, made on the 30th of August 2024. That order translating into financial effect various findings made by the judge in his judgment handed down on the 21st of June last year. The judgment, for your lordships' note, is at CB 10. And I'm sure your lordships have had the opportunity of considering it.
Yes.
As your lordships will know, by his order, the judge required my client to make an additional payment to BC in the sum of around £8.9 million. That was said to be a further payment by way of third-party income due pursuant to the terms of a waste management project agreement, which everyone refers to as the PA, and I'm going to do the same today, concluded between the parties on the 17th of April 2013. Now, in broad measure, the PA required my client to construct an energy from waste facility at Great Moor. For your lordships note, an energy from waste facility effectively takes residual waste, burns it, and then effectively what is burnt is translated into electricity, which is then sold on to the national grid. So we were to construct that facility, and then we were to operate and maintain Great Moor and originally 2 other waste transfer stations in High Heavens and Amersham. As matters transpired, Amersham wasn't required. The deed of variation takes Amersham out of the PA. For present purposes, the parties are concerned with the effect of the PA only. Now, importantly, this was a contract which was to run for a 33-year period, and it was to allow Buckinghamshire to comply with its statutory obligations to divert waste away from landfill. Both parties say the judge was right in certain respects and wrong in the other. My client, FCCB, says that no additional payment was due from it by way of TPI, and that the judge should accordingly have dismissed BC's case. And my client invites this court to do the same thing, and you've seen that from our appellant's notice. On the other hand, Mr Mort's client says it should have been awarded a much greater sum by way of TPI, and it invites this court to vary the sum awarded so that it will become entitled to £16.7 million. Before turning to the detail of the construction exercise, I want first to make some introductory remarks about the structure of the PA, because in my submission, the structure of the PA is critical to understanding how the TPI arrangements worked, and also to make some introductory remarks about the type of waste that was going to be treated at these facilities. One further introductory observation to make at the beginning, my lords. The court will have appreciated that underpinning this PA is a complex maze of contractual definitions, which the court will find in Appendix 1 to the PA. When one enters the maze of the definitions, one finds one's taken hither and thither because one definition refers to another and to another. And one can start with what thinks is quite a straightforward journey into Appendix 1 and find 20 minutes later one is still there, tracking down all of the associated definitions. So to that end, what I'm intending to do is that unless a definition is central to my submissions, I'm simply going to inform the court that it's a defined term and tell the court where it might be found in the definitions. So, starting first, my lords, with the structure of the PA. I've already indicated that the project consisted of the construction of Great Moor and the management and operation of 2 waste transfer stations. What Buckinghamshire contracted for in this regard was services in relation to the treatment of its own waste, i.e. waste that it had a statutory obligation to treat, and under this PA that is defined as contract waste. If your lordships note, that's core bundle tab 33, page 822. And importantly, Buckinghamshire contracted with FCCB, who was an SPV created for the single purpose of being the contractor under this agreement. Contracting with an SPV is entirely usual in PFI projects or contracts of that nature. And the reason for that is it's seen as being beneficial to both parties. From the authority's perspective, it's beneficial because the facilities are ring-fenced from the performance of the remainder of the contracting group. So when one contracts with an SPV for the purposes of a PFI contract, it is, of course, obviously necessary to step down the obligations which the SPV owes to a series of subcontractors who undertook the substantive performance of the obligations under the PA. In this PA, those subcontracts were known as ancillary documents, and that's a term defined at core bundle tab 33, page 814. And express provision was made for ancillary documents in clause 10 of the PA, tab 33, page 681. Now, in turn, in order for BC to be given protection, it entered into a series of collateral warranties with the subcontractors who warranted their performance under the subcontract to BC. Again, collateral warranties is a defined term, and one can find that in the bundle at page 819. And the obligation to provide collateral warranties one finds in clause 12 of the PA at page 684. Now, diagrammatic representation of the contractual structure which was in fact put in place for the purposes of this contract can be seen in FCC's final tender to BC. And for these purposes, my lords, if I could invite you to take out the supplemental bundle at tab 41. What this document is, my lords, is an extract from FCC's final tender to Buckinghamshire. And the way the document works is right up at the top of the page at page 865. One will see a little box that is the text from Buckinghamshire's invitation to tender. So Buckinghamshire states what it wants, and then underneath one sees how the tenderer is proposing to provide or respond to that requirement. And the one sees at 2.1, proposed structure, group proposing to implement a contractual structure widely used in the delivery of waste infrastructure projects in the UK in order to ensure familiarity and promote understanding of the nature and level of risk borne by each of the parties, each of the project parties, and thereby enhance delivery, etc., etc., etc. And then one sees in the next paragraph the reference to the creation of the SPV. And then over the page at 866, one sees what at first sight might look like quite a frightening diagram, but actually in reality isn't when one gets to the heart of it. In the middle of it, one sees that dark navy box headed WRG SPV. WRG, my lords, was a reference to Waste Recycling Group. That was the name of the company prior to its takeover by its now Spanish owners, FCC. So what this contract, what this diagram shows is right at the top one sees Bucks CC entering into the contract with the SPV, the PA, and then effectively the SPV entering into a series of subcontracts with a variety of different subcontractors. So coming down under the box WRG SPV, one sees reference to the EPC contract. That was the contract to construct Great Moor, which was entered into with a company there called A&E Innovia. And then to the right of the WRG SPV box, one sees the reference to the O&M contract. That was the contract which the SPV entered into to operate and maintain the facilities once they were constructed. And that was with a company called WRL, which is now known as FCCR. And then
the first company wasn't an associated company, but this one was.
Yes, my lord, yes. So A&E Innovia is I think it's a Swiss company who specialises in the design and manufacture of EFW plants, yes. Effectively. Coming directly underneath the EPC and the O&M contracts, one sees a whole variety of other subcontracts. And the relevant one for these purposes is the contract which is entitled C&I contracts. And again, one sees that that was to be entered into with WRL. C&I is short for commercial and industrial. And what that was about the contract which was going to be entered into for the supply of the balance of the waste that was going to be brought into the facilities. And one sees that, my lords, over on page 867. Under the heading WL third-party waste supply. The third-party waste supply contract will be with a group's wholly owned subsidiary that will be guaranteeing delivery to the SPV of tonnes in excess of the forecasted contract waste. That was the waste that Buckinghamshire was going to deliver at a guaranteed gate fee of £66.50 per tonne. And then it says that heads of terms can be found. And for your lordship's note, those are in the bundle at tab 40. Unless your lordships would be assisted, I'm not proposing to take your lordships to those. Now, for these purposes, the important point to note is that both the O&M contract and the third-party waste supply contracts were contracts into which FCCR entered into collateral warranties with the council. So the way this worked, my lords, was that under the PA, FCCB, the SPV, was obliged to treat contract waste, that was Bucks waste, and it was also entitled to treat third-party waste, but my lords, it was not obliged to do so. Under the O&M agreement, FCCR agreed to operate and maintain the facilities and to treat both contract waste and any third-party waste that came into the facilities in return for receiving payments from FCCB. Those payments were calculated by reference to what was known as the O&M payment. And in broad terms, they were applied by identifying a price per tonne and multiplying that price per tonne by reference to the total volume of waste treated. Now, returning to the waste supply agreement, it was necessary to conclude that agreement because the facilities had been sized to be able to treat significant volumes of third-party waste. And again, for your Lordship's note, that's a defined term at page 849 of the bundle. And it was also necessary to have that agreement in place because FCCB had guaranteed that a specific amount of income would be received for treating that third-party waste. And the way in which that income was to be used was it was going to subsidise the cost to Bucks of treating its own contract waste. So from BC's perspective, it needed to be satisfied that an organisation capable of securing the supply of third-party waste not only had a contractual obligation to do so, but more importantly from BC's perspective, that that organisation was obliged to pay FCCB the amount of the guaranteed third-party income. In turn, FCCB required that guaranteed third-party income from FCCR in order to cover its own costs involved in the facilities, and if necessary, in order to make a further payment to Buckinghamshire under this contract. Now, my lords, all of this was made clear to Buckinghamshire in the financial model, which was provided with FCC's tender and which was ultimately incorporated into the project agreement as Schedule 20. My lords, everyone refers to the financial model as the base case. They're interchangeable terms and they mean the same thing. Your lordships have got extracts from the base case in your bundles. However, they're extremely small and hard to read, so I've taken the liberty of blowing them up to A3 and also of extracting certain parts of the base case for the purposes of my submissions. These are not intended to be controversial. If it would assist your lordships, you can see the Excel model in all its glory.
We have been sent the Excel model, but I have to say I'd much rather have your hard copy versions.
Mr. Casmy's going to hand them up to the bench. Actually, the Excel model is not as frightening as it looks, my lord, and if I can find my way around it, I'm absolutely certain the bench can. So there are a series of tabs here. I want to start, my lord, with looking at the tab marked Financials, which is the first tab in this little bundle of documents. And just if your lordships were so minded and wanted to do their own research, one sees right at the bottom of this page the line of tab titles, and in the middle one sees the reference Financials, which is underlined in green there.
So that's the one we've got an extract from here.
Exactly, my lord, and we've just identified that at the top of the page there. This is an extract from a very, very long financial spreadsheet. These are the financials for the SPV, i.e. FCCB. And the reason, of course, it's so voluminous, my lords, is that it runs for the entire 33 years of the contract. And so the number of columns that one sees running from left to right reflect the duration of the contract. And it's entirely possible to select to sell for a given month or period in this 33-year contract and see how the financials work out as one runs through it. For present purposes, my lords, I'm interested in the navy blue line right at the top, SPV profit and loss.
Yep.
Now, in very simple terms, my lords, what this does is it looks at the financial situation from the perspective of the contracting counterparty, FCCB, and it identifies the revenues that FCCB will receive and the costs which FCCB has to defray from the revenues that it receives. And my lords, I just want to draw your attention to a number of line items. Line item 39, which is entitled Unitary Charge. And one sees the figure there, 41,927. Those are millions, my lords. That is the amount that the SPV received from Buckinghamshire for the treatment of Buckinghamshire's contract waste over this 33-year period. And then, my lord, one sees row 41, commercial revenue. And one sees the figure 609,525. I've just been told by my juniors that I've made my first error in terms of the base case. I said these figures were millions. In fact, they're thousands. So that's... I see. It's 41 million.
I suppose 609 million.
Yes, exactly, my lord.
Yeah.
So this is the figure which the SPV was going to receive by way of commercial revenue, and it was receiving that revenue from FCCR, who had the obligation to source waste and to pay the guaranteed income to FCCB. So one sees the flowing down and then the flowing back up. And then there were a whole number of other revenues which aren't really relevant for the purposes of this appeal. But then under the heading operating costs at row 49, one sees at line item 52 the reference to O&M costs of 629,407 million. That's the amount that the SPV modelled that it was going to have to pay FCCR as the O&M contractor to operate and maintain the facilities in accordance with the O&M contract. And just while we're here, my lords, if one turns on to tab 4 of this bundle, this is the extract from the base case under the tab O&M PayMec. And if your lordships would be good enough to cast their eyes down to row 54, one sees O&M total revenue 629,407. Which is the figure that I've just referred the bench to in the Financials Profit and Loss tab. And that figure, 629,407, was calculated, as one can see if one looks further up the page, by the application of costs per tonne to various bands of waste.
Sorry, just show me that.
So 629,407. My lords, it's best. If your lordships would be good enough to find column AR on row 54.
Yes.
This is working through because, of course, the total figures don't show one how it operates as a mechanism. So at cell AR54, one sees the figure 1124.
Yes.
That is taken from the total payment at row 54, just up the column.
Yes.
And that figure at 51 is the sum of the amount for the band 1 payment at row 40 of 950 and the band 2 payment at 1174.
Yes. And so just picking up the point you were making, the band 1 is 100,000
Band 1
times
operates
97.23 with an indexation, is it?
Absolutely, my lord. And we'll see how this works in a slightly different way when we come to look at the SPV payment. Essentially, 100,000 is the guaranteed minimum tonnage that Buckinghamshire was going to deliver to the authority. And importantly, my lord, you'll see that obviously the band 1 price here, £97.23, much higher than the band 2 price of £9.24. And the band 2 price was to operate between 100,001 tonnes and 320,000 tonnes Now, that 320,000 tonnes is the maximum mechanical capacity of the plant. So if you ramp it all up and let it run for as long as it possibly can, it could theoretically process 320,000 tonnes of waste.
And it's being projected to do so.
I'm so sorry, my lord.
And it's being projected to do so.
No, my lord. So the way the way that the base case works, my lord, is it's modelled on the plant processing 292,500 tonnes, and that's based on a series of assumptions about the availability of the plant and the amount of time well, effectively the availability of the plant, my lord. So it's the 292,500 tonnes is effectively the tonnage that one gets from operating the plant for 87% of the available time it could be operated for.
And so just, I'm sure this doesn't matter, but so I understand, in arriving at the 174 that we get as a band 2 payment, we see that 924 is applied per tonne subject to an indexation.
Yes.
So the assumption is that it's 192,500 on top of the 100,000, which is how you get to your 290.
Absolutely. And when I said a moment ago to my lord that the base case is modelled on 292,500.
It's 100 plus 190.
Absolutely. And so what one sees here is the O&M payment being modelled on payments based on the plant treating 292,500 tonnes of waste.
Yeah.
Which in itself is, in fact, my lords, if your lordships can actually see that. If you turn to tab 5 of this bundle, in yet another tab of the base case is something called the Assumptions tab. And at this tab, my lords, one sees on the left-hand side the words availability in a box. And underneath that one sees the line item base tonnes per hour, the availability being 89.04%. I said 87, I do apologise. But one gets the general picture here.
Yep.
And that's 89% of 24 hours a day for 365 days of the year.
Yeah.
And so, of course, one's not modelling on 100% because one needs to think about downtime for maintenance, or indeed if the plant breaks down and needs to be repaired. So it's modelled on a sort of a reasonable steady state of operation, but it can be ramped up, or if things go wrong, then obviously the projections which the base case is based on, namely treating 292,500 tonnes of waste a year, will not be met. And if that happens, that's a risk which is borne by the SPV. So, my lords, I hope one can see from the SPV Financials tab that the importance of the SPV receiving the third-party income from FCCB under the Waste Finder. The terms of the Waste Finder also required FCCR to pay FCCB if it received a tonnage of waste in excess of that on which the guaranteed third-party waste income was based. So the guaranteed third-party income is based on essentially the 292,500 less the contract waste delivered by the authority, which equates to about 182,500 tonnes of third-party waste. But if the plant is running at 320,000 tonnes a year, then obviously more third-party waste can be accepted and treated, and the gate fees which FCCR receives are commensurately bigger. FCCR passes that up to FCCB. Which then shares the additional amount with the authority in accordance with the provisions of the PayMec, which we'll look at in a moment. So as I've already indicated, FCC as the tenderer was required to identify the amount of guaranteed third-party income which was included with its tender. And to indicate how that would affect the price that Buckinghamshire paid for the treatment of its own waste. And that was an important factor in Buckinghamshire's evaluation of all tenders which it received, which, as your lordships will know, was an evaluation which had to be conducted in accordance with the relevant public procurement regulation regime. And my lords, one can see that from Buckinghamshire's invitation to submit detailed tenders, which is in the supplemental bundle at tab 30. And for these purposes, my lords, if I could invite your lordships to turn on to 730. This is in a part of Buckinghamshire's invitation in which it set out what it wanted to receive back from the tenderers. And at paragraph 21.27.2, if I could just invite your lordship's attention to that paragraph, your lordship will see what Buckinghamshire there said.
Sorry, which page is that?
We're at 730, my lord.
Thank you.
Now, it's worth noting, whilst we're in this document, my lords, that Buckinghamshire also asked bidders to provide estimates of non-guaranteed third-party income reasonably expected to arise and any gain share derived from that income. And your lordships will see that if one turns back in this document to page 722. At paragraph 21.5.1, halfway down that paragraph, bidders are also asked to provide an estimate of any non-guaranteed third-party income reasonably expected to arise, and in accordance with the requirements of the payment mechanism, any gain share that the council may be expected to directly benefit from. Any non-guaranteed third-party income should not be used in the pricing of the unitary charge. As a matter of fact, FCC did not identify any non-guaranteed income as part of its tender. And my lords, one can see that if one looks back in this little bundle again of the extracts from the base case. At tab 3. What this tab does, my lords, is it sets out how the SPV modelled the operation of the payment mechanism under the project agreement. And for current purposes, my lords, the relevant row is row 45, which is just up from the top hole punch. One sees the reference there, T, third-party income, 0, and then one tracks that all the way through, and one sees zeros all the way through this page. Were your lordships to interrogate the Excel that's been provided to you, you'd find that the zeros ran all the way through the 30-year, 3-year period. So although the sums which were guaranteed TPI clearly played a major commercial role in the deal which the parties concluded, non-guaranteed TPI played no part at all in that deal. My lords, next I'd like to look at where the waste comes from.
And when you say played no part at all, there was obviously going to be a contractual entitlement
Absolutely.
on the council's part to receive it.
Absolutely.
It's not modelled here, but they will have known they were going to receive it.
The point, my lord, is from one sees from the ISDP that tenderers were asked, if you expect any third-party income reasonably to arise from your proposals, please identify that in your tender. And as a matter of fact, FCC did not identify any other third-party income apart from the guaranteed amounts. And that's what I'm saying, as in it formed no part of the assessment for the purposes of concluding that FCC was the contractor who offered best value for money to the authority. And whilst, of course, the contract provided for BC to receive excess third-party income, at this stage, the tenderer was saying, we do not expect any to arise.
Yeah.
The source of the waste, my lord. I'm going to start with a bit of geography. And for those,
So we can put away.
you can put away that file for now. I'm afraid to say we might have to return to it at a later stage. We're in the core bundle now, my lords. It's tab 33. Which is in the contract. And for these purposes, my lords, could your lordships go to page 993?
Yeah.
and just to put a bit of colour on what we're talking about. Page 993 is an extract from Schedule 13, which is entitled Delivery Points and Contingent Delivery Points. At the top there, one sees a map of Buckinghamshire County Council, Buckinghamshire Council and the surrounding environment. And one sees the big dot at the top of that map, that's Great Moor. And then towards the bottom of it, two further dots, one marked High Heavens Transfer Station and the other marked Amersham Transfer Station. So the way this worked, my lords, is
I
that...
worked out why there are two maps. Is there any difference?
My lords, one are delivery point. No, my lords, I don't think there are for these purposes, actually.
Yep.
The way this was going to work from a contract waste perspective is that, as one can see, Buckinghamshire is a large county. Buckinghamshire contract waste could be delivered to any one of those delivery points, Great Moor or High Heavens, or at the beginning Amersham, but everyone accepts Amersham's not constructed, so we can forget about Amersham. So that's contract waste. Convenient at this point, my lords, to turn to consider where third-party waste might have come from at the point in time that the PA was actually executed. Then to look at where, in fact, it did come from during the period with which this claim is concerned, and then to look at where it comes from now. As to where it might have been expected to come from, it might be convenient to pick that up in Buckinghamshire's own final business case, which was prepared for the purposes of the council authorising the entry into this contract. And one sees that, my lord, in supplementary bundle tab 42. At page 877. And I'm interested in paragraph 5.7, markets for outputs and third-party waste. And my lords, if I could just invite your lordships to just read that paragraph.
Through just the first paragraph?
Just, the section which is in under 5.7.
Do you mean all the way through to the end of the next page?
I mean to the gate fee for existing and proposed merchant plants is likely to be higher than. So to the bottom of page 51, my lord.
Yeah.
So, my lords, a number of points to take from this paragraph. Firstly, the distinction between C&I and municipal waste. C&I waste stands for commercial and industrial, and that's generated by businesses or factories, but is distinguishable from municipal waste, which is in essence household waste, which a waste disposal authority has a statutory obligation to collect and treat. So what Buckinghamshire understands the position to be is that third-party waste would at this point primarily come from commercial and industrial waste generated in Buckinghamshire and its surrounding areas. But it notes that there may be a possibility of waste coming from municipal waste disposal contracts and those are contracts concluded with other waste disposal authorities for the purposes of the treatment of their municipal waste. So the points, my lords, just coming back to the map that we were looking at a moment or two ago at 993, is that at the time of entry into the contract, the third-party waste could have come from anywhere. And could have been sourced from anywhere. Now, as to where it in fact came from, and sticking with this map, it in fact came from Luton, which your lordships will see to the right of this map, just above the hole punch. It also came from Hitchin, which one sees to the northeast of Luton by the A1M sign. It also came from Stevenage, which is to the southeast of Hitchin. It also came from Waterdale, which is a transfer station just to the north of Watford, which one sees almost parallel to the Amersham transfer station. And finally, it came from Hendon, which one doesn't see marked on this map, but for those of you who don't know, is in northwest London.
All the others being in Hertfordshire.
All the others being in Hertfordshire. Actually, I'm not sure Luton is in Hertfordshire.
Bedfordshire.
Bedfordshire. Bedfordshire and Hertfordshire. And the waste that arrived, that came from Hendon, had been collected from North London waste disposal authorities. And that waste went on the train from Hendon up to the train station at Calvert, which was located in the same compound as the Greatmore Energy from Waste facility. And that waste arrived because FCC group companies had contracts to provide waste management services to those waste disposal authorities that I've just mentioned. So that's Hertfordshire, Luton and North London Waste Authority. And the services provided under those contracts differed in each case, and accordingly so did the nature of the income received. So by way of example, focusing on Hendon in North London, that was a contract concluded between the North London Waste Authority and an FCC group company known as FCCW. And that was a contract to haul the waste from Hendon to the Calvert rail station and then dispose of it at Greatmoor. So those are quite specific and distinct services. At the other end, there was a contract which FCCR had with Luton Borough Council. And that was known in the industry as a multi-services contract. And under which FCCR provided a very many number of services, including construction of new facilities, operation of household recycling centres, and an operation of a waste transfer services facility. And we'll look at that in a bit more detail later on. And Hertfordshire, which is the most complicated of all, chose to do things very differently indeed. So whereas Luton had a multi-service approach, Hertfordshire adopted what in the industry is known as a disaggregated services model. Where it procures individual services under separate contracts. And that led to a series of complicated contractual arrangements. They're summarised in our closing submissions. I'm just going to give you the reference, which is at the supplemental bundle, page 683. Where you can see them all and how they changed over time. For these purposes, my lords, though, the contracts with Herts required FCCW again to do three sorts of things. Firstly, to manage the Herts transfer stations at Waterdale and Hitchin. And just pausing there to note that my learned friend Skeleton refers to us owning those transfer stations. We didn't own the transfer stations. We were required to manage them for other waste disposal authorities. So firstly, we've got the management contracts. Secondly, there are contracts to haul waste from Herts waste transfer stations to Greatmoor. And thirdly, there is a contract to dispose of the waste at Greatmoor. Where FCC had a disposal obligation, which it did to Hertfordshire and it did to North London Waste, it performed that obligation by entering into a separate contract with FCCR, who, as the operator of Greatmoor, agreed to accept the waste at the facilities in return for the payment of the gate fee. Viewed through the lens of the project agreement, there were two sorts of reasons why it was necessary for FCCW to enter into that contract with FCCR. There was an operational reason. FCCR was the plant operator and it held the relevant environmental permit necessary to operate the facilities. So that meant that it was FCCR that was on the hook if waste was accepted which was in breach of the environmental permit. So it was necessary for FCCR to be able to say, we don't want that waste because we're not entitled to treat it. And if FCCR said that in relation to any of the FCCW waste that came from Hertfordshire or North London, FCCW took the cost risk of dealing with the rejected waste. So that's the operational reason. There's also a commercial reason, and that's this. The commercial structure which underpinned the PA was predicated on a basis that envisaged that the revenues to which FCCB is entitled as third-party waste income would be generated by FCCR, with FCCR being obliged to pass them up to FCCB under the Waste Finder Agreement. So that FCCB could then account for that income to Buckinghamshire in accordance with the terms of the PAYMEC. There was no contractual nexus between FCCW and FCCB. So FCCW had no obligation to make any payment to FCCB. Still less to BC. So the FCCW-FCCR agreement was the only contractual mechanism by which third-party income could flow up to FCCB. And your lordships will see a copy of the FCCW-FCCR agreement in tab 11 of the supplemental bundle. And at page 390, one sees the agreement dated the 9th of December 2014. This is the agreement which FCCW enters into in relation to the North London waste.
I do apologise. What tab is this?
It's tab 11, my lord, of the supplemental bundle. Just for your lordship note, there's a similar one in relation to the Herts waste, and that's at tab 7. And at the recitals one sees at page 390, whereas FCCR operates the EFW, and B, FCCWS requires disposal arrangements. One sees at the next page 391 FCCW obligations, which effectively at 2.1 are to pay, one might expect, but also at 2.1.2 to remove any rejected waste. And that was the waste that FCCR couldn't treat because it was in breach of the environmental permit. And then over the page at 392, FCCR's obligations, 3.2, 3.1, make the facility available, 3.2,
Sorry, make the facility.
in consideration of the payments to be made to FCCR, FCCR shall provide and make available the EFW to FCCWS for the delivery of the waste.
Yep.
So that was effectively to allow FCCW to bring the waste in. 3.2, the obligation on FCCR to maintain those permits necessary to run Great Moor. And then at paragraph 4, clause 4, just at the bottom of 392, the obligation to pay, which is that the payments due and payable for the services during the hours set out at clause 3.1 shall be £75.97 per tonne. Now, just pausing there, it's absolutely common ground between us that the £75.97 per tonne that FCCW paid to FCCR was less than the disposal fee that FCCW received from, in this case, North London. And your lordships can see that it's just literally a few pages further back in this bundle behind tab 10 at page 386. My lords, this is the pricing schedule in the contract between North London and FCCW. And one sees there the first two items one can ignore because they deal with how waste was going to be treated prior to Great Moor's coming into service. And then items 3 and 4 deal with what was to happen when Great Moor was in service. So you can see at line item 3, it says to be used from 1st of April 2016 for the remaining contract period. And one can see there that FCCW was receiving £90 per tonne from North London. And my lords, so the £90 per tonne was the disposal fee. And then additionally, it was receiving £7.10 per tonne for hauling the waste from Hendon Rail Transfer Station to the Calvert Rail Head near Great Moor. So common ground that FCCW received more from North London than it paid to FCCR. In our respectful submission, there were many commercial and operational reasons why this was so. But to give your lordship just two examples, the first one is that FCCW retained the risk of dealing with rejected waste and the costs associated with that. And secondly, FCCW had to bear the costs of getting the waste from the Calvert railhead up to Great Moor. And that required men to offload, and women, presumably, to offload the waste from the trains into trucks and then drive it a half a mile from the rail transfer station up to Greatmoor. So, as I've identified, my lords, three arrangements with three different waste disposal authorities, all of which are on different terms and which require the FCC group company to provide different sorts of services to the other WDA. As a matter of fact, all of those municipal waste contracts have now expired. And the unchallenged evidence before the judge was that, in the light of the approach that Bucks had taken to the calculation of third-party income, FCC concluded that it could not enter into any further arrangements with the municipal authorities. On any sensible commercial terms. And that was the evidence of Mr. Stephen Longdon, who is the FCC UK Group's CEO. And your lordships will find that evidence in the supplemental bundle behind tab 19. And the relevant page for your lordship's note is page 593. There, under the heading Impact on Local Authority Contracts generally, Mr. Longdon explains what Buckinghamshire's approach has meant in terms of FCC's approach going forward. And what this means in practice, my lords, is that from 2023 all the way up to today's date, and it is anticipated going forward, third-party waste will come from FCC's commercial competitors, which are companies like Viridor, Grundon, Shanks, who all operate in the waste services business, and they will bring their waste to the gate of Greatmoor, in return for which they will be charged a gate fee by FCCR. But there will be no further income from haulage, because those commercial contractors are paying their own costs of hauling the waste to Greatmoor. So FCC, none of the FCC companies are making any haulage money anymore. And there will be no further income from managing waste transfer stations outside of Buckinghamshire.
So
Not only-
just going back, I forget the dates of all these other contracts. The Hertfordshire contract, say, was entered into on the basis that the waste would go to Greatmoor.
It depends what one means by the Hertfordshire contracts,
Yes.
my lord.
Well, when you say the FCC companies are no longer going to be getting any money from managing the waste transfer stations
Absolutely,
in
my lord.
Hertfordshire, that's because
Those contracts have expired. As a matter of fact, those contracts have expired. And what's actually happened is that Hertfordshire is now constructing its own energy from waste facility. And so Hertfordshire has just changed the way in which it's managing its waste.
And I don't know whether you did bid for that, but you could have bid for that, presumably.
We could have bid for that. There were other municipal authority contracts that we could have bid for. And indeed, Mr. Longden's evidence talks about contracts that we did in fact, FCC did in fact bid for, but lost out on. Because as your lordships will appreciate, all of these contracts are being procured under public procurement regulations, with all of the attendant complications in that process. So,
Forgive me, what's the relevance of that? The fact that these have expired, etc.?
the fact that these have expired, my lord, is simply that there is the way in which the industry operates is each waste disposal authority can choose very many different ways within which to dispose of its waste. Although the Hertfordshire contract has expired and the Luton contract has expired and the North London waste contract has expired, there are many other authorities who at the same time are looking to procure waste management services and might well have been interested in using a Great Moor facility as their ultimate disposal facility for their contract waste. The point that Mr. Longden makes in his evidence is that because of the approach that Buckinghamshire has taken in terms of asserting that it is entitled to 75% essentially of gross income, with FCC not being entitled to any of its costs, it is simply, they cannot commercially bid for waste contracts from the other waste disposal authorities.
Because it's uneconomic. I see, right.
So when it might when it might have been economic to bid on the basis you're going to use Great Moor, it ceased to be.
Absolutely. And it ceases to be economic because essentially Buckinghamshire's interpretation, and indeed the interpretation found by the judge, mean that FCC bears the lion's share of the costs associated with running those projects, but has to give credit for 75% of the gross revenue it receives from each of the authorities.
Save that, subject to argument over the provisos, to the extent that you could show that you were incurring additional costs as a result of running one of these projects, you could take that into account.
Well, we'll look at how that works in a moment, my lord. We say that the additional costs works not just in terms of as a result of one of these projects. All of these projects incur additional costs because they are additional costs which are not covered by the base case, which deals only with the costs of operating the Great Moor facilities.
But the base case comes in sort of in the provisos.
It doesn't just come in with the provisos, my lord.
I see, okay.
And we'll come to look at that in a moment. We'll get there, my lord.
Okay.
Not only does the FCC group not generate any additional income, it obviously doesn't incur the costs either that are the subject of this claim. So that's how the PA works, and that's how the waste comes into the project and where it might come from at any one point in time. Next, I want to make a few observations about the approach to construing this project agreement.
So we should put away the...
You can put away the
files,
supplemental bundle. My Lords, I'm hoping to do this relatively quickly in terms of my reference to the authorities, because I'm sure these are authorities that your Lordships have cited to you almost on a daily basis.
I think that's right, because in all honesty, reference to authorities on contractual interpretation doesn't normally take you anywhere.
No, absolutely, my Lord. So I'm going to make some very brief observations in this regard. Now, although your Lordships are concerned with interpreting the definition of third-party income, which, as I'm sure your Lordships will know, will be found at 848 of the core bundle, the question of the true and proper interpretation of that term has to be answered in relation to the context in which the term is used within the project agreement itself. And the starting point for this contract is clause 77, which your Lordships will find at the bundle at page 744. That's the core bundle, Lords. 77, third-party income. The provisions of paragraphs 3 and 11 of Schedule 15 shall apply in respect of third-party income. Schedule 15, my Lords, is the payment mechanism. It sits at the heart of this project agreement, and it governs the quantum of the payments to be made by BC to FCCB, or in certain circumstances by FCCB to BC. And just for your Lordship's note, when BC invited tenders, it requested tenderers to produce payment mechanisms which followed something called WIDIP guidance. WIDIP is an acronym for Waste Infrastructure Delivery Programme, which was set up by the Department of Environment to provide guidance to both authorities and tenderers about tendering and operation of long-term waste contracts concluded in accordance with PFI type forms. And just for your Lordship's note, you can see it at the bundle, you don't need to turn it up, supplemental bundle, tab 30, page 713, which is the reference in the tender. Schedule 15 does three things, my Lords. Firstly, it defines and quantifies a single payment that Buckinghamshire will make to the contractor for the provision of the services under the payment or under the agreement. That's commonly known as the base payment. It also provides for deductions to be made to the base payment by the authority if the contractor fails to deliver services in accordance with the standards required under the contract. And that regime, my Lords, replaces a damages for breach of contract regime. And finally, the PayMec provides a mechanism for the sharing of the third-party income generated by the asset which is the subject of the agreement. And the interrelationship of those three features can be seen from paragraph 3, which is in the core bundle, tab 33, page 1013. And this is one of the paragraphs that clause 77 of the PA directed us towards.
So we're in schedule
15.
15.
My Lords, which starts, it's quite a lengthy schedule. Your Lordships will see it starting at page 1000.
Yep.
And the way in which this works is there's yet another series of definitions. And then at paragraph 3 on page 1013, reference to the unitary charge. And for current purposes, I'm interested in clause 3.2, monthly unitary charge. 3.2.2 describes how that unitary charge is going to be calculated. And your Lordships will see that there are a number of components in the calculation. For these purposes, my Lords, the relevant ones are MBM, and TY. So MBM is the monthly base payment, calculated in accordance with paragraph 3.4. And then on the top of 1014, one sees TY, third party income share, calculated in accordance with paragraph 11. And then at paragraph 3.2.3, one sees that TY is to be included only in the final contract month of each year. And at 3.2.4, you can see, my Lords, that the unitary charge can be a positive sum or a negative sum, reflecting which way the payment goes. (3.4) is the monthly base payment. That's the amount of money that Buckinghamshire pays to treat its contract waste. And essentially, that figure is calculated by applying a base price per contract tonne of waste treated. And one sees that, my Lords, if one turns up to 1031, what one does here, as one can see, is it depends on the volume of contract waste that the authority sends to be treated each year as to which payment band applies. But the payment which is to apply to something called the minimum tonnage of contract waste, which is a defined term, but for your Lordship's note, is that 100,000 tonnes that you might remember looking at in the O&M payment. And so for the first 100,000 tonnes, one is using what is called the base case, band 1, base price per tonne. And that, my Lords, is a defined term. One turns back to page 1004. Just by the lower hole punch, you see those words there. and it means the Band 1 price set out in cell C59 of the SPV payment tab in the base case, as updated from time to time in accordance with the provisions of Schedule 19. And just turning back to our little tab, our bundle of extracts from the base case, turn to tab 3. One sees at row 59, cell C, the figure of £6.
Sorry, where do I see cell C59?
So 59, effectively, my lord, it's
Oh, I
that
see, yes.
yellow,
Yes.
yellow and red item.
Yeah, I follow. So it's column C.
Column C, so yeah, row 59, £6.68. And one also sees there the words in a box, only NTP goal search in order to achieve required, and the words have been cut off there. But essentially, my lords, £6.68 is the figure that is derived by the SPV when it calculates the income that it's going to receive, the outgoings, costs it's going to incur, so those items in that financials tab we looked at the very first thing, and generates for the SPV an IRR, internal rate of return, of 10.74%. So what the goal seek function is doing is essentially, if one were to change any of the assumptions underlying, it effectively, the model reacts to create whatever the base price is. So the point about the base price is one can see how it's then subsidised by the third-party income received from both the treatment of waste and the generation of electricity as guaranteed in and set out in the base case. So that's how the guaranteed income feeds into the price that Buckinghamshire is paying. Now, as to the dealing with any additional TPI, one is directed towards paragraph 11 of this PAMEC, which starts at page 1023. And one can see that it is a function of 4 particular components. Now, just by way of note, my lord, it is not clear from BC's pleaded case which of these components is said to give rise to the entitlement to third-party income claimed in these proceedings. Or indeed how that sum feeds through up the line into the calculation required by by paragraph 3 of Schedule 15. Now, although, my lords, that might be thought of as a bit of an old-fashioned pleading whinge, actually the substantive point here for the court is that the court will be required to identify which of these components is relevant for the purposes of calculating any additional entitlement. And for the purposes of the construction exercise, in my respectful submission, in particular, it requires the court to understand how the term TPI, third-party income, is actually utilised in paragraph 11. And it appears 4 times, my lord. Paragraph 11.2.1, under the recyclate output excess TPI share, one sees ARTPI, actual third-party income derived from recyclate's output. It appears under paragraph 11.3.1 on the next page, 1024, under the heading AETPI, actual third-party income derived from electricity output. It appears under the heading 11.4, third-party excess TPI share, actual third-party income received by the contractor for the treatment of third-party waste at the facilities for the relevant contract year. And then one sees it again at paragraph 11.5 over the page at 1025, EOTPI, other third-party income. The important point, my lords, from this is that, save in relation to paragraph 11.5, the term third-party income is qualified by reference to the source of the generated income, i.e. it's derived from recycler output, it's derived from electricity output, it's derived from gate fee revenue received over and above that generated by the guaranteed third-party waste. And just again, by way of note, and we'll pick this up when we come to look at Luton later on, when it's used in those senses, third-party income is derived from the existence and operation of the facilities.
And when you say in those senses, you mean through to paragraph 11.4?
Yes, my lord, yes. Now, obviously, paragraph 11 in Schedule 15 says nothing about how one goes about calculating actual third-party income. And for that, one does indeed need to look at the definition, which we'll go on to do in a moment. But in my respectful submission, the starting point is to identify which paragraph one is dealing with. And that's because the definition of TPI directs the reader towards considering the costs directly incurred in the context of the type of income generated as TPI.
Since I feel that phrase might be important, can you give it to me again? Say, towards costs directly incurred.
In the context of the type of income generated as a result of incurring those costs. So one can see that the nature of the costs that one might incur, for example, in generating third-party income derived from recyclates output might be very different from the nature of the costs that one might incur in generating TPI derived from electricity output, etc., etc. And that's why I say it's necessary to start at the beginning by identifying which paragraph of 11 we're actually operating under. Now, in terms of the approach to construction, my lords, I'm just going to make 4 basic propositions.
Yep.
I can take your lordships to the references, but I'm hoping that these are not controversial propositions. Firstly, the meaning of the words to be construed is to be determined by what a reasonable person, having all of the background knowledge available to the parties, would have understood those parties to mean by the language that they use. What does that mean in this context? Firstly, in my respectful submission, it means that the parties have knowledge of the waste industry and the way in which the waste industry operates, because they are both players within it. The parties can also be taken to know that because this is a lengthy contract, the assumptions made in the base case at the beginning might vary by the time one gets to the middle or to the end. And that means in terms of maximising third-party income, there might be any number of permutations about how that might be achieved, each of which would come with its own specific associated cost profile for the reasons that I've just explained. Secondly, this was a tender process conducted in accordance with the procurement regulations. The reason why that's specifically important here, my lords, is that BC's stated requirements weren't just important to FCC, they were important to all tenderers who tendered in accordance with those regulations. BC expressly stated that it wanted this contract to operate on the basis of what it called SOPSI 4 and WIDIP principles. We've looked at WIDIP very briefly, my lords. SOPSI 4 was guidance published by the DTI, again about how PFI contracts might operate over time. And it's SOPSI 4 which specifically talks about the stepping down of those SPV obligations to the subcontractors. In terms of third-party income, what BC told tenderers was that whilst it expected to benefit from income generated by the facility, clearly the operator needed to be incentivised and reap the benefits of its efforts. And the reference to that, my lords, is in that invitation document we looked at earlier, pages 718 and 719. The relevance of the WIDIP and the SOPSI 4 documents are important here for exactly the same reasons as they were, as the Court of Appeal found that the ISDA User's Guide was a relevant aid to construction in the Netherlands and Deutsche Bank case. And that's in your bundle of authorities, my lord, tab 15.
Should we just look at that?
Yes, my lord, yes. Is this an authority with which your lordships are familiar?
I'm not familiar.
This is an authority about the construction of an ISDA standard form and about whether or not interest payments could be a negative sum.
I'm sorry, which tab in the authority?
Tab 15.
15, okay.
And it's a judgment of the Chancellor, as he then was. There'd been a change in interest rates over the duration of the ISDA agreement. They had gone from positive to negative, with the results that there was an argument about whether or not a payment flowed one way or the other. The parties were relying on ISDA guidance in support, ISDA guidance not referring to the making of a negative payment, and what the parties could have concluded or drawn from that. And there were two sets of ISDA guidance, importantly, my lords. There was a set of ISDA guidance which had been produced before the relevant contract in this case was entered into. And then there was some guidance which was produced after this contract was entered into. And the Court of Appeal concluded that both sets of guidance were relevant to the construction exercise. And the relevant passages for your lordship's note start at the discussion on pages 332 and we place particular emphasis on paragraphs 53 and 56.
Meaning we should read those.
My lords, yes.
Yeah.
I'm so sorry, I must have got the page wrong.
It's 332.
Oh, 332. Okay.
You might usually start at paragraph 52, which introduces the debate.
Yeah. And the CSA was a contract concluded between these parties.
Yes, my lord, yes. And my lord, we do place some weight on paragraph 56 of the judgment, where the Chancellor notes that this is a case where some assistance can be gained from the factual matrix available to the parties seeking to use the ISDA forms. The user guide makes no reference to negative interests being provided for. And we say that in this case, in circumstances in which Buckinghamshire told tenderers that it wanted a contract which was SOPSI 4 compliant and which reflected WIDIP principles, those documents are part of the factual matrix, and are to be used for the purposes of ascertaining precisely what the purpose of a particular clause in this very complex agreement was designed to mean.
And the point we get from paragraph 56 is specifically about post-contract documents.
Absolutely, but my lord, if one...
Are you relying on post-contract?
No, we're not relying on post-contract
No,
documents to be...
So actually it's more straightforward.
It's much more straightforward than that, my lord, yes. And in fact, my learned juniors have highlighted that I should perhaps have referred your lordship to paragraph 49, subparagraph 4 at page 331, where it talks about the drafting of the agreements are aimed at ensuring consistency with the guidance as a whole. And my lord, just to take your lordship back to paragraph 56, if I may, I'm not sure it's quite solely directed towards a post-contract guidance, because it refers to a user's guide published in 1999 in relation to an ISDA form which was published in 2001 and 2010. It does indeed go on to talk about the later guidance, but it's also saying that the earlier guidance, which also didn't refer to negative interest, is relevant too.
Yes, well, it was accepted the former guidance. The unusual point in this was that...
Yes, absolutely, absolutely, my lord, yes. Yes, absolutely. And we say in our case, we don't need to go as far as the Court of Appeal in Netherlands, but it's quite clear that the exercise in Netherlands involved the court looking at the guidance, published guidance in relation to a form that the parties then used, and identifying what that published guidance shows. And we say, my lords, that in this case, when one looks at the definitions and when one looks at the way in which this PAMEC operates, your lordships are required to have regard to the purpose of these provisions as explained by the SOPSI and WIDIP guidance. So perhaps that first point took me rather longer than I'd hoped, but it was the iterative exercise which is a submission which I think is one that's well familiar to your lordships. Second proposition, my lords, in terms of construction. The exercise involves the court in testing different interpretations against the commercial purpose of the provision. And for that, my lord, I don't expect your lordships to turn it up, but we do rely on Rainy Sky at paragraph 43. In which the court found that it was not necessary to conclude that a particular construction would produce an absurd or irrational result before having regard to the commercial purpose of the agreement. And my lords, we do say that the commercial purpose of the clause is different to questions of business common sense.
Hang on, sorry. Commercial purpose is different from business common sense.
Absolutely, my lord. And my lords, one can see that if one looks at Arnold and Britton, where the commercial purpose of the clause was to identify a fixed sum payable by reference to a service charge. As a matter of business common sense, the result was remarkable, but because the construction which the court had arrived at reflected the commercial purpose, namely to fix the sum payable, and the court described the clause in Arnold and Britton as being akin to a liquidated damages type provision. The fact that commercially, as things turned out, the result was catastrophic is irrelevant.
I mean, in another sense, it's just in Arnold and Britton the words were sufficiently clear to override whatever one might think common sense suggested.
Well, my lord, they were sufficiently clear in the context of the commercial purpose of the clause itself. And one can see that what Lord Neuberger does, in particular paragraph 26 of his judgment, is he looks to the commercial purpose of the clause. And in that context, yes, the words were sufficiently clear. But you start by saying, what's this clause trying to do? So that was proposition number 2. Proposition number 3, in terms of the iterative process, words only become obvious and have one meaning when they're viewed in the context in which they're used. So, for example, turned red might mean it was a loss-making enterprise. It might mean someone got embarrassed, or it might mean they got angry. One only knows when one sees the context in which it is used what those words are designed to mean.
I think this is a particular Lord Hoffman theme, going back to investors' compensation scheme.
If your lordship wishes to associate me with Lord Hoffman, I won't. Yes, it is. But one gets the point, and when we look at this clause in a moment, we'll see how that particular point plays out in this contract. And finally, my lords, we do emphasise that this is a long-term, complex contract. And courts, when construing these types of contracts, have said that the focus should not be on the individual words used, but on identifying the purpose of the contract as a whole. And for that proposition, my lords, I rely on Lord Justice Jackson in a case called Amy Birmingham, which was itself a PFI case. And again, it might be just worth turning that case up, which is at A14 of your authorities bundle. And it's at page 309. In the right-hand column, Part 8, conclusion. This was a PFI roads contract, and it was about maintaining and operating roads for Birmingham City Council. And at paragraph 92, Lord Justice Jackson notes the contract before the court is a PFI contract intended to run for 25 years. He makes an observation about relational, which isn't relevant here. And then at paragraph 93, he says this. I do, however, make this comment. Any relational contract of this character is likely to be of massive length, containing many infelicities and oddities. Both parties should adopt a reasonable approach in accordance with what is obviously the long-term purpose of the contract. They should not be latching on to the infelicities and oddities in order to disrupt the project and maximise their own gain. And then in paragraph 94, he makes the observation that the contract had worked sufficiently well for the first 3.5 years, and things only went wrong when the contractor thought up an ingenious new interpretation of the contract.
But he also says in paragraph 95 that he would reject that interpretation for the reasons set out in paragraph parts 5 and 6.
Yes, yes, my lord, yes.
And I don't know what's in parts 5 and
well,
6.
I mean, it's going through essentially what had happened in that contract was ABHL had identified what one might have thought of as a very technical argument about the interrelationship between various schedules in order to assert that it did not have a particular obligation to fix some potholes for Birmingham City Council because it said it fell out with the content of those schedules. And what Lord Justice Jackson is doing in this case is he's going through it and he's saying it'd be a pretty remarkable state of affairs if you have a contractor to maintain and fix roads and somehow the contractor is not obliged to fill a pothole. In a nutshell is where this case gets to, which is why he makes the comment about the infelicities and oddities.
Yeah.
And again, just for the court's note, that observation is also reflected in a judgment of Mr. Justice Eyre in the High Court in a case called Solutions for North Tyneside, which is yet another PFI contract, this time in the context of housing repair, and that's the 21 of the bundle. And at paragraph 103, he makes the observation that there is an element of artificiality in both stances, though it was most marked in the defendant's argument. Both arguments overlook the fact that there is almost inevitable in contracts of the length and complexity of those connected with the project that there will be infelicities in the drafting, and there may be definitions which are worded in a way which on a strict logical analysis is circular, but whose meaning will be more or less easily and clearly discerned when set in context. And then he goes on to talk about the need to set the subcontract in the context of the contract. So, my lords, for those reasons, we do urge the court to have particular regard in these circumstances to the purposes behind third-party income sharing arrangements. And to the authorities' expressly stated observation that the purpose of the third-party income regime was not just to allow the authority to benefit, but that the contractor should be incentivised and reap the benefits of its efforts as well. By way of, those are by way of introductory observations about how one goes about construing this contract. Now I'd like to turn, my lords, to look at the definition itself, which your lordships will find at page 848 of the core bundle, behind tab 33 in the contract definitions. My lords, I'm now dealing with ground one of my appeal, which is that the learned judge was wrong to find, as he did, that with the exception of the haulage costs, all of the costs incurred or which FCCB sought to deduct from the income were not costs directly incurred in generating the income. And my lords, you have my point that it's the nature of the income with which one is concerned before one turns to think about how the costs, whether the costs are or are not directly incurred in generating that income. And for those purposes, my lord, it might be sensible if we just examined the way in which these costs, what these costs are and how they arise. And for those purposes, my lords, if you could find, please, tab 18 of the core bundle. My lords, I suspect that you have some really small A4 spreadsheets there.
Sorry, which
It's
page?
tab 18, my lord. This is part of
I'm
my
probably
own
looking at the wrong page.
friend's
Sorry,
core
I'm
bundle.
Tab 18.
tab 18 of the supplemental bundle.
Core bundle.
Core bundle, sorry. I'm seem to entirely the wrong place.
Yes.
Quite small, I think, my lord, on there. If it would assist, I can get the relevant pages blown up for the court over lunch.
Let's see if we can manage.
I would like, my lords, to start, please, at page 263. And for these purposes, my lord, we need 263, 264, and actually that will probably suffice. What this document is, my lord, is part of Buckinghamshire Council's pleaded case. And it arises in this way. As your lordships will know, following the Part 8 decision of Mrs. Justice O'Farrell, which concerned the meaning of income in relation to two specific contracts. One contract concluded with Hertfordshire and the North London contract. FCC was obliged to identify all third-party income arising under various heads, and it also set out the costs which it intended to deduct from that income. And my lords, it did so having drawn the costs from its own internal accounting software systems. And the way in which those accounting systems work is that FCC identifies the relevant facility. So in the case of North London Waste Authority, the costs are identified by reference to North London Waste Authority. And the accounting system identifies the income that the relevant FCC receives from North London. So in this case, it will be income received from income received by FCCW under that contract that we looked at a moment or two ago. And then the accounting system records all of the costs which are incurred in order to provide the services to North London Waste Authority. And so, my lords, if one just looks at page 264, one finds the heading North London Waste Authority at the top left of that spreadsheet.
Yes.
Immediately below it is the word tonnes. That's the amount of waste which went from North London Authority to Greatmore in this contract year, which is 2019 to 2020. And then immediately below the revenue figure, which is the amount which North London pays FCCW to haul the waste and treat the waste at Greatmore. So in 2019-2020, North London paid FCCW, if one looks at the far right of that page, 8.3 million. And then immediately below that, one sees a line item costs. And line items 1 to 9 are costs which are recorded in FCCW's accounting system as being incurred by reference to the North London Waste Authority contract. So, for example, if one sees item 2, manpower, this spreadsheet shows that in relation to North London, FCCW incurred costs of £322,565 in the year 2019-2020 in relation to the manpower deployed to deal with the North London waste.
I'm sorry, I must be being slow. I can't see where that figure comes. Partly because it is all very small.
I'll get these blown up over lunch, my lord.
But it's the line starting headed manpower to the left.
Absolutely, my lord. And then if one goes right to the end of that line.
Yeah. 322465.
That's correct, my lord.
Is that the figure you were saying?
Yes, it is.
I'm sorry, I
my
thought
lord.
you said 522. Anyway.
No.
Thank you.
And the same is true for all of these other items of cost.
Yes.
What happened after these figures were produced is the parties very sensibly agreed a sampling protocol.
Just before you say that was what those are costs 1 to 9.
Yes, my lord.
Obviously not the costs thereafter.
They're not the costs thereafter. The overheads costs, my lord, are dealt with at a different level because they are the group overheads, which are then translated down and applied to each of the individual group companies. In accordance with a series of intra-group agreements. And we'll come to look at the evidence about those in a moment. So, my lords, in relation to all of these costs, and that includes the overheads as well, what happened was that the parties agreed a sampling protocol. FCC opened its books, or its computer terminal, and BC was given the opportunity to sample all of the costs, the figures which underlay this spreadsheet. And it made various requests for various documents, and it attended various meetings with FCC personnel. And as a result of that process, in December 2023, it wrote to say that with 3 exceptions, it agreed that all of the costs recorded on these spreadsheets had in fact been incurred.
You said that they had been incurred, or they were accurate as figures?
They were accurate as figures in terms of manpower, that they had seen the underlying documents the contracts of employment. So the manpower figures, my lord, comprised a series of individuals associated with a particular project. So as one goes through this is a summary of something extraordinarily complex in terms of an accounting system, but it is possible when one sees the accounting system to go through it with a degree of granularity which enables you to identify the individual operative working in a particular site and to identify the timesheets. Where equipment is hired for the site, it is possible to identify the invoice from the hiring company. So all of these figures are capable of being broken down to a very, very granular extent. And indeed, the sampling protocol process took place over a 4-month period in 2023. During which BC was entitled to request any document it wanted, and FCC agreed to provide them. And just for your lordship's note, the sampling protocol itself is in the supplemental bundle at tab 1.
Can we put away the core bundle, or do we need to keep that to hand?
You do need for it. You do. We are coming back to that in a moment, my lord.
So the sampling
Supplemental bundle tab 1. Your lordship will see that this is an order of Ms. Borough Lane, King's Council, sitting in the TCC, dated the 27th of April 2023.
And we see the agreed sampling.
Absolutely. And your lordships can read through that and see essentially what that envisaged. But the result of that protocol being followed was that in December of that year, my learned friend's solicitors wrote to my solicitors and said that with 3 exceptions, they agreed that all of these costs had in fact been incurred.
And at that stage, the argument became not whether they had been incurred, but as to whether they were directly incurred or within the
Absolutely.
provisos.
Were they directly incurred, and did they meet the provisos?
Yeah.
Is there any relevance as to how this was all treated for tax purposes? I imagine it fed into computations of trading profits, or
That's an extraordinary. The answer is standing right here. I don't, I'm afraid, know the answer to your lordship's question, but I can find out over the shorter term.
maybe a complete red herring. I was just wondering, when one's looking at setting off gross receipts against deductions, costs and so forth in the context of a trading relationship, one way that is going to be reflected is obviously in the accounts which are drawn up, and where a similar test not dissimilar in some respects probably is likely to apply.
And your lordship's right about that. And in fact, I have got the Group FD sitting behind me, so I will actually get the answer for your lordship over the short adjournment.
Thank you.
For current purposes, however, these are costs which everybody accepts. There are receipts for, etc., etc., etc. And as my Lord Justice Newey has identified, the debate then shifts to, are these directly incurred in generating the income? Now, I want to look at that in the context of the North London Waste Authority contract, because in my respectful submission, when one sees how this works, the suggestion that these are not directly incurred costs is, with respect, a rather far-fetched one. So for those purposes, my lord, we are, I'm afraid to say, you can now probably put away the core bundle. We're back in the supplemental bundle. And we're at tab 10.
Sorry, which one?
Supplemental, my lord.
One I had open. 10. Yeah.
Tab 10, my lord. Just at page 347, one sees this is the contract, London Waste, that's North London, and FCCW, 9th of December 2004, on its face, rail transfer and treatment of municipal waste. Now, under the contract, in return for complying with the obligations FCCW owed and supplying the service, North London was obliged to pay FCCW the contract price, and one sees that, my lord. If your lordships, my lords, if your lordship please return on to page 368. C1.1, in consideration of the contractors, that's FCCW's, performance of its obligations under the contract, the client, North London, shall pay the contract price in accordance with Clause 3, payment and VAT. What Clause 3 does is it provides various provisions about weighing the waste. For current purposes, my lords, the relevant reference here is to contract price, which is a defined term under this contract at page 352. Contract price means the price payable by the contractor to the contractor, so price payable to FCC by the client under this contract as set out in the pricing schedule for the full and proper performance by the contractor of its obligations under this contract. So the income which FCCW receives under the contract with North London Waste is income received for the full and proper performance by FCCW of its obligations under this contract. In terms of the pricing schedule, my lords, that's the sheet that we've already looked at earlier on this morning at page 386 of the bundle. And your lordships, as I've already explained, will see that what happens is NLWA pays a price per tonne for disposal and transport as set out in the amounts there. And just for your lordship's note, the amounts there identified, when multiplied by the tonnage of waste which North London sends to Great Moor, as we saw in that spreadsheet a moment or two ago, equates to the revenue that FCCW receives from North London. Now, in terms of what the services which FCCW agreed to provide in return for that contract price were, they were set out in the specification, which your lordships can see starting at page 374 of the bundle. And I'm interested in 375 over the page to 376. The contractor shall provide the following service to London Waste for the duration of the contract period. 2.1.1, transportation to the contractor's nominated treatment or disposal facility site and the treatment and disposal. And then 2.2 is also important. Contractors should allow for all costs associated with the transportation, treatment or disposal of the contract waste at their nominated facilities. This includes, among other things, taxes, handling charges, permits, licences or other shipment costs required to facilitate the movement of contract waste from the premises that's Hendon Rail Transport Station, to the contractor's nominated disposal / treatment site, that's Great Moor EFW. My Lords, clause 10 is also of some relevance here at page 379. Operational requirements. Contractor shall be responsible for the payment of all necessary track access and maintenance charges. 10.1, ensure necessary train paths and connection agreements with Network Rail are secured in advance of the commencement date. And then 10.5, again, on which we do attach some importance, the contractor must transfer the full ISO containers by rail to their nominated treatment or disposal facility, then remove the full ISO containers from the train and empty them of contract waste. No material should be extracted from or added to the contract waste on the journeys without the prior written consent of LWL. What that's involved, my Lord, was the exercise I described earlier on this morning of taking the waste off the train at Calvert, putting it into trucks and driving the trucks up to Great Moor. Just on at 381, and then we'll stop for the short adjournment.
Yes. 381.
381. Paragraphs, clauses 12 and 13. Contractor was to provide all equipment for the effective and efficient operation of the treatment and disposal facility and associated rail transport operation. 12.2. Maintain the equipment. 13.1, shall at all times during the contract period employ sufficient persons to ensure that the service is provided and ensure that every person so employed is at all times properly skilled, honest, experienced, instructed and supervised. And then 13.2, a belt and braces shall provide all labour, plant and materials necessary for the operation and management of the treatment or disposal facility and for the rail transfer and disposal of contract waste, except where expressly stated to the contrary. I think that might be a convenient moment, my Lord.
Thank you very much. So 2 o'clock.